International law is the set of rules generally regarded and accepted as binding in relations between states and between nations. It serves as a framework for the practice of stable and organized international relations. International law differs from state-based legal systems in that it is primarily applicable to countries rather than to private citizens. National law may become international law when treaties delegate national jurisdiction to supranational tribunals such as the European Court of Human Rights or the International Criminal Court. Treaties such as the Geneva Conventions may require national law to conform to respective parts. Much of international law is consent-based governance. This means that a state member is not obliged to abide by this type of international law, unless it has expressly consented to a particular course of conduct. This is an issue of state sovereignty. However, other aspects of international law are not consent-based but still are obligatory upon state and non-state actors such as customary international law, and peremptory norms. Terminology. The term international law can refer to three distinct legal disciplines. Public international law, which governs the relationship between states and international entities. It includes these legal fields: treaty law, law of sea, international criminal law, the laws of war or international humanitarian law, international human rights law, and refugee law. Private international law, or conflict of laws, which addresses the questions of which jurisdiction may hear a case, and the law concerning which jurisdiction applies to the issues in the case. Supranational law, or the law of supranational organizations, which concerns regional agreements where the laws of nation-states may be held inapplicable when conflicting with a supranational legal system when that nation has a treaty obligation to a supranational collective. Branches. The two traditional branches of international law are jus gentium, law of nations, jus inter-gentes, agreements between nations. History. The modern study of international law starts in the early 19th century, but its origins go back at least to the 16th century, and Alberico Gentili, Francisco de Vitoria and Hugo Grotius, the fathers of international law. Several legal systems developed in Europe, including the codified systems of continental European states and English common law, based on decisions by judges and not by written codes. Other areas developed differing legal systems, with the Chinese legal tradition dating back more than 4,000 years. Although at the end of the 19th century, there was still no written code for civil proceedings. Some doubt the effectiveness of international law, as they see the implementation of international law as a policy option among others to tackle global dilemmas. They say that international law must be evaluated with other, possibly more effective, international law options. Types of international law. Public international law. Public international law concerns the treaty relationships between the nations and persons which are considered the subjects of international law. Norms of international law have their source in either custom or customary international law, globally accepted standards of behavior, or codifications contained in conventional agreements, generally termed treaties. Article 13 of the United Nations Charter obligates the UN General Assembly to initiate studies and make recommendations which encourage the progressive development of international law and its codification. Evidence of consensus or state practice can sometimes be derived from intergovernmental resolutions or academic and expert legal opinions. Private international law. Conflict of laws, often called private international law in civil law jurisdictions, is distinguished from public international law because it governs conflicts between private persons rather than states. It concerns the questions of which jurisdiction should be permitted to hear a legal dispute between private parties, and which jurisdiction's law should be applied, therefore raising issues of international law. Today corporations are increasingly capable of shifting capital and labor supply chains across borders. as well as trading with overseas corporations. This increases the number of disputes of an interstate nature outside a unified legal framework, and raises issues of the enforceability of standard practices. Increasing numbers of businesses use commercial arbitration under the New York Convention 1958. Supranational law systems of supranational law arise when nations explicitly cede their right to make certain judicial decisions to a common tribunal. The decisions of the common tribunal are directly effective in each party nation, and have priority over decisions taken by national courts. The European Union is an example of an international treaty organization which implements a supranational legal framework, with the European Court of Justice having supremacy over all member nation courts in matter of European Union law. International courts. There are numerous international bodies created by treaties adjudicating on legal issues where they may have jurisdiction. The only one claiming universal jurisdiction is the United Nations Security Council. Others are the United Nations International Court of Justice, and the International Criminal Court and the Court of Arbitration for Sport. East Africa Community. There were ambitions to make the East African Community, consisting of Kenya, Tanzania, Uganda, Burundi and Rwanda, a political federation with its own form of binding supranational law, but this effort has not materialized. Union of South American Nations. The Union of South American Nations serves the South American continent. It intends to establish a framework akin to the European Union by the end of 2019. It is envisaged to have its own passport and currency, and limit barriers to trade. Andean Community of Nations. The Andean Community of Nations is the first attempt to integrate the countries of the Andes Mountains in South America. It started with the Cartagena Agreement of 26 May 1969, and consists of 4 countries: Bolivia, Colombia, Ecuador and Peru. The Andean Community follows supranational laws, called agreements, which are mandatory for these countries. Bibliography. I. Brownlee, Principles of Public International Law. World Encyclopedia of Law, with International Legal Research and a Law Dictionary.